Okay, so good day taong bayan, your quote-unquote favorite DDS lawyer po, who is also your quote-unquote ang pogi ni attorney lawyer, is back po for another video. At before po tayo mag-start, bawas-bawasan niyo po sana yung pagsabi sa akin or pagtawag po sa akin ng quote-unquote ang pogi mo attorney kasi medyo lumalaki na po yung ulo ko At mahirap naman po kung medyo, ayoko po kasi yumabang talaga okay? Kaya bawas-bawasan niyo na po sana yung mga ganong comments at mag-focus po talaga tayo sa mga issues na dinidiscuss natin kasi yun naman po yung goal ko talaga dito sa mga videos ko. Hindi ko po to ginagawa para basically magpapogi. Gusto ko lang po maging entertaining yung batas sa inyo, the viewer, the taong bayan, para mas mas maging interested kayo sa mga ganap dito sa bansa natin. Okay, pero anyway po, going back to the topic, yung video po natin today will be the bangayan between Senator Marcoleta and DOJ Secretary Boying Remulla kasi nagkaka-misunderstanding po sila between or regarding the Witness Protection Program. As per Senator Marcoleta, gusto niya i-admit sila Discaya. Kay SoJ Remulla, ayaw naman niya kasi hindi pa daw nagkakaroon ng restitution or yung pagbalik ng mga allegedly ninakaw daw ng mga Discaya. Okay, so before ko po explain yung mga legal side of things, ipe-play po muna natin tong video between them, yung discussion between them, para po magka-idea kayo kung ano tong issue at kung bakit sila nagkainitan. Okay?
Mr. Secretary, a couple of days ago, in the last hearing when you were here, we somehow settled the issue that restitution is not a requisite for an applicant to the WPP. Is that correct?
It's not in the law. But sa akin ko kasi, hindi lang po batas na nagdidictate dito. It's also what is morally right, what is expected of us. Yan po kasi kahit hindi nilagay sa batas, mga given po yan sa ating lipunan.
What do you mean by that, Mr. Secretary?
Kasi wala nga sa batas yung,
Wala nga sa batas.
yung
Then,
requirements
ano lagay mo sa
for admission to the witness protection. Ang restitution is not part of it.
Yes, it is not.
Pero hindi mo nangangahulugan na hindi namin pwede i-layout yan depending on the case.
Mr. Secretary, I am still in the stage where a particular applicant wishes to apply under that program. And there is a process. In the process, restitution is not one of the requisites. Is that correct?
Opo, pero if it's in terms of this case being a financial crime, sir, this is a crime against the financial status of the Filipino people, of the Philippine Republic. I think that it's just right.
Mr. Secretary, are you amending the provision of...
No, sir. No, sir. But that is how we run the witness protection program.
As a lawyer, Mr. Secretary, may I ask you, in a criminal prosecution, the civil liability is impliedly instituted. Is that correct?
Of course.
Kaya nga hindi naman nangangahulugan kung sakasakali na natapos na yung criminal prosecution. Kapag ka nakita na mayroong criminal liability yung tao, because it is impliedly implied, doon lang magkakaroon ng restitution. It will come after. Paano mo sasabihin na magre-restitute ang isang tao? Meron na bang findings kung magkano i-restitute on how it can be restituted? Nag-a-apply pa lang Huwag po ninyong babaguhin ang requisite ng batas, Mr. Secretary. I thought nung dumating ka dito, nag-aintindihan na tayo Kaya nabablar ang proceedings natin Kaya nga kinote ni, siguro, ang chairman kanina gusto kong ituloy ito, sinabi niya, nagpa-interview siya, na goodwill and sincerity should be done para i-test. Pwede ba yung ganito?
I respect your opinion, sir. But
it is not my opinion, it is in the law, Mr. Secretary.
Yes, sir. But I am operating...
The arbiter
sir,
is the law.
Can I speak, sir?
Yes, you
I'm
are
operating from the vantage point of the reason behind the law, sir. What is the reason behind the law? So that we can get justice, and justice can only be attained if there's restitution. So that is the principle behind all of these things that we are talking about now.
Mr. Secretary, restitution will come after. It cannot be...
So it can come before or after, sir. It can come before or
You
after.
cite the law that it come before. Wala nga po sa batas Huwag po ninyo babaguhin ang batas, Mr. Secretary.
We are operating on a unique set of facts, and we are... All of these matters are being evaluated because the gravity of this financial crime cannot be underestimated. And that the more assets that we're able to preserve at the outset, the better for our country, sir.
Mr. Secretary, I'm very sorry for such a reasoning like that. Alam mo,
I'm very sorry, sir. Also, sir, I'm very sorry too, if you do not agree with me. But I respect your opinion, sir, and we will carry out our job as we deem fit, as we see.
Mr. Chair, I said I am not expressing an opinion here. I am articulating the provision of law. You do not change the provision of law, Mr. Secretary. You may be disbarred from doing this.
Then, it's your opinion, sir. It's your option, sir.
Sinabi ko na nga hindi ko opinion ito. I am
Then it's your option, sir. If it is what you wish to happen, that you may proceed
Ikaw ang
with what you
nagbibigay
wish.
ng opinion, nilalagay mo yung restitution to test the goodwill of a possible applicant. It is not in the law. Unless you are able to point out the provision of law that it come before. Hindi ganun Sabi mo na nga, and we admitted, impliedly instituted ang civil liability, but this will come eventually after the court has pronounced kung magkano ibabalik niya kung meron man. Not before. Thank you, Mr. Chair.
Are you done, Senator Marcoleta? Okay. So next in line is Senator Padilla.
Okay. Tapos na. Nagkainitan, di ba guys? So ganito po yan para mas maintindihan talaga ninyo. Yung position dito ni Senator Marcoleta is that kung ano yung nasa provision ng batas, yun yung dapat i-implement strictly. Kasi if we read RA 6981, the Witness Protection Program Law, wala naman pong restitution talaga doon na nakalagay sa requirement. So ipapakita ko yun siya sa inyo rin later, okay? And dito naman po kay Secretary Boying, since sila po yung government office or the government body na binigyan ng power to implement the Witness Protection Program Act, meron daw po silang discretion to add extra requirements requirements considering or depende po kung ano yung kaso na involved. And since dito, this involves a financial crime as per Secretary Boying dito, so dapat daw ibalik muna yung pera before ma-admit sa witness protection program yung Spouses Discaya. So yan po yung summary ng mga legal positions nitong dalawa. Okay? So yung batas po natin dyan is this one po, RA 6981, an act providing for a witness protection, security, and benefit program and for other purposes. Okay, so kung naliliitan po kayo dito sa naka-flash sa screen, pwede nyo po yan i-zoom in pag nasa YouTube kayo nanonood. So tanggalin nyo na lang po itong mukha ko at ito po yung tutukan ninyo yung provisions para mas maging klaro talaga tayo. Okay, so unang-una po, explain ko muna yung general principles of law natin para maintindihan nyo talaga. So di ba like what I have already repeatedly explained sa inyo, yung structure po kasi ng government natin is that number one, yung legislative branch, yung Congress at Senate, yung may primary power to legislate or to create laws, diba? Tapos yung executive branch po, which is kasama po yung Department of Justice doon, sila yung may kapangyarihan naman or may duty to implement and execute the laws. Okay, so ito pong RA 6981, ginawa po to ng Congress. So ngayon, ang mag-implement yan is of course the executive branch via the Department of Justice. So makita po natin yan dito sa Section 2, Implementation of Program. The Department of Justice, hereinafter referred to as the Department through its Secretary, shall formulate and implement a witness protection, security, and benefit program, hereinafter referred to as the program, pursuant to and consistent with this provision of this Act. Okay, so dito po, Section 2, it is very clear, DOJ yung may trabaho to implement. Okay, tapos dito naman po yung next dyan, Section 3, Admission to the Program. So ito po, basahin nyo na lang to isa-isa. And then next po niyan, makita nyo A, B, C, D, yung requirements to be admitted as part of the witness protection program. So unang-una po, the offense in which his testimony will be used is a grave felony as defined under the revised penal code or its equivalent under special laws. Diba? The offense in which his testimony will be used is a grave felony. So yan po yung highest type of criminal actions or crimes dito sa bansa natin. And more or less, sa tingin ko po, although wala pa po kasi talagang fina-file against kila Discaya, pag magkaroon na po ng filing of cases, it will most likely be a grave felony considering the amounts involved po dito po sa mga allegations against them. Okay? And then letter B po, his testimony can be substantially corroborated in its material points. So when you say substantially corroborated, ibig sabihin po niyan, merong other evidence na magsusupport pa dun sa testimony ng witness na yon. Okay? And then letter C, he or any member of his family within the second civil degree of consanguinity or affinity is subjected to threats to his life or bodily injury, or there is a likelihood that he will be killed, forced, intimidated, etc. etc. In short, meron pong threat sa safety and security talaga niya or members of his family within the second civil degree. At kung ako po tatanungin ninyo, merong threat considering, di ba, sinugod po yung mga bahay yung bahay po ng Discaya tapos pinagbabato. And then letter D po, he is not a law enforcement officer even if he would be testifying against the other law enforcement officers, etc. etc. So klaro naman po na yung mga Discaya ay hindi rin sila law enforcement officers. Okay, so yan po yung requirements ng under the witness protection program as specifically provided by Section 3, admission into the program. So sa side po ni Secretary Remulla, di ba klaro naman kanina dun sa Section 2 nakalagay na DOJ yung may power or may trabaho to implement this law, specifically the Witness Protection Program. Okay, tapos kung makita po natin sa Section 18, Rules and Regulations, nakalagay din po kasi dito, the Department, which is the Department of Justice, shall promulgate such rules and regulations as may be necessary to implement the intent and purposes of this act. So ito yung ginagamit kanina ni Secretary Boying, kung napapansin po ninyo, di ba, yung intent daw and purpose of the law, meron daw siyang power to promulgate. So ito po yun under Section 18 in relation dito nga sa Section 2, Implementation of Program, the Department of Justice. So ngayon, ang next question dyan, since meron tong Section 2 at Section 18 na pwede nga gumawa ng rules and regulations as may be necessary to implement the intent and purpose of this act, does it mean po ba na absolute yung authority ng Secretary of Justice sa pag-promulgate mag-promulgate nitong rules and regulations na gagamitin po sa pag-implement ng batas na to. At ang sagot po dyan is hindi po yan siya absolute kasi this is what we call po a delegated legislative authority. Okay? So kung meron pong mga law students na nanonood sa akin ngayon, at least this is a very good case po para mas ma-visualize ninyo kung ano ba talaga yung delegated legislative authority, yung mga completeness test, sufficient standard test. Pag pinapag-aralan po kasi ito sa law school, medyo masyado tong bookish na topic eh. Pero ngayon po, it is very interesting considering diniscuss na to nila Senator Marcoleta and Secretary SoJ Remulla. So the reason po kung bakit delegated legislative authority yung tawag dito sa ito under ng Section 18 and Section 2 kasi yun nga po, di ba, like what I've already explained numerous times, yung primary legislative authority is vested with Congress by our Constitution, di ba? Section 1 of Article 6 po yun. Therefore, hindi po pwede basta-basta lang gumawa ng rules and regulations yung mga other government bodies kasi that will go against the very primary function of Congress po. However, in very specific cases, in certain cases po, pwede po magka-delegated legislative authority provided masusunod yung tinatawag na completeness test and the sufficient standard test. Okay? And unahin ko po muna i-explain sa inyo kung ano ba yung sufficient standard test. So when you say the sufficient standard test, dapat po yung batas na nagbibigay ng delegated legislative authority to a different government body which is not the legislature, dapat there is sufficient standards na gagamitin or magiging guide dun sa government office na yon sa paggawa po nila ng rules and regulations sa pag-implement ng batas. Okay? So ngayon tingnan po natin kung meron bang sufficient standard in this case po sa RA 6981. So kung titingnan po natin sa Section 18 Rules and Regulations, kung ako po tatanungin from how I understand this provision and how I read it, this passes what we call the sufficient standard test. Okay? Kasi kung titingnan po ninyo, ang nakalagay, the department shall promulgate such rules and regulations as may be necessary to implement the intent and purpose of this act. So ito yung standard na kailangan sundin ng Department of Justice sa paggawa po nila ng rules and regulations sa pag-implement. Dapat po hindi siya lalampas sa intent and purpose of this act. So kung ano yung intention ng batas, ano po yung purpose nitong batas na to, dapat yung rules and regulations must correlate to that specifically. Okay, so ang nangyayari dito ngayon si Secretary Boying, according to him, the intent and purpose of this law daw is to give justice to the Filipino people. Therefore, pwede daw niya dagdagan ng additional requirement yung provisions. Ang masasagot ko lang po dyan, with all due respect to him, I do not absolutely agree with his legal position considering the purpose of this law, the intent and purpose, is not necessarily to give justice to the victims or to the persons affected. Kasi kung makikita po natin sa title pa lang, it states here, an act providing for a witness protection, security, and benefit program and for other purposes. Okay? So ano po ba ibig sabihin ko niyan? Ang ibig sabihin ko po niyan, the main intent and purpose of this law is to give protection to the witness. Hindi po to give restitution to the damages or loss of the victims of the crime. That's how I understand it po, diba? Kasi yun nga, Witness Protection, Security, and Benefit Act. So from there po, makikita natin, the main intent and purpose is para maprotektahan po yung witness. Therefore, hindi po dapat tayo nagdadagdag ng requirements na hindi naman nakalagay sa batas that will make it more burdensome for a witness who is applying to this program. Okay? Yan po yung legal position ko on the matter. Diba? Kasi kung tatandaan nga natin, Section 18, it states such rules and regulations as may be necessary to implement the intent and purposes of this act. So tandaan po ninyo, hindi ko po sinabing not guilty yung mag-asawang Discaya. Ine-explain ko lang po sa inyo paano ba gumagana yung sufficient standard test in relation to delegated legislative authority kung saan pumasok na tong Witness Protection Program Law. So kung susundin po kasi natin yung argument doon ni Secretary SoJ Remulla, magiging burdensome to the witness applicant. Therefore, we could argue na that defeats the intent and purpose of this law, which is to give protection dun sa safety and security of witnesses of mga grave felonies. Okay, that is how I understand this law. So in simpler terms po, my main point is hindi dapat dagdagan yung requirements because it will go against the very essence of the intent and purpose of this law, which is to give protection to the witnesses. Okay? Anyway, masyado na pong napahaba yung explanation ko regarding the sufficient standard. Medyo technical po to, actually boring to actually sa law school pag dinidiscuss. Okay, so when you say the completeness test naman po sa delegated legislative authority, it means that the law must be complete, meaning na even without the regulations, the rules or regulations nung naigagawa po nung implementing body, ay may intindihan pa rin talaga natin yung substance nung batas. Yan po yung simplest way na ma-explain ko. Dapat kompleto siya kung saan maintindihan na natin yung main purpose ng law even without the rules or regulations pa po nung implementing body. So in relation to the requirement provisions of this law, may kita naman po natin na the law is complete as to that, diba? Kasi nakalagay dito, Section 3, admission into the program, provided that A, B, C, D, may specific requirements lang, which is yung mga binanggit natin kanina. So kung makita po nyo, it passes the completeness test and the sufficient standard test. Therefore, valid yung pag-delegate ng legislative authority dito sa DOJ. However, kailangan po natin tandaan, hindi po porket valid yung delegated legislative authority is ibig sabihin meron ng absolute legislative power yung DOJ. Hindi po yun ganun. Kasi yun nga po, dapat yung rules na gagawin ng DOJ dito must be in accordance with the intent and purpose of this act. Diba? So this one po, this is already complete. Hindi na to pwede dapat dagdagan or bawasan ng DOJ. And number 2, since intent and purpose, yun nga yung sa section 18, kung magdadagdag tayo, we will make it more burdensome for the witness to apply, then that will defeat the very essence of the intent and the purpose of this law. Okay? If there is a valid delegation of legislative power to the implementing body, to the executive branch, kailangan pa rin po sundin ng executive branch ng implementing body yung sufficient standard na sinet ng batas, pati hindi rin po dapat galawin yung pagiging complete ng batas na, di ba? In other words, yung pwede lang po dito gawin nila Secretary Boying is mag-promulgate sila ng mga rules and regulations kung paano to ma-achieve tong A, B, C, or D. So when we talk about restitution po kasi, it does not merely supplement A, B, C, or D. It is actually an additional requirement po which is not in the law. Therefore, pag ganun, that will be beyond their delegated authority to legislate po. That is my legal position on the matter. Pero kung ipilit pa rin po talaga nila Secretary Boying na may additional requirement of restitution, so papasok po yan ngayon under what we call the principle of presumption of regularity. So kung gusto talaga to questionin nila Senator Marcoleta ng mag-asawang Discaya, they have to go to court po and more or less they will have to file a mandamus, a petition for mandamus. So alam ko naman po na itong pag-apply or pagpasok sa Witness Protection Program, it is not a ministerial function agad, diba? Kasi meron pong specific requirements eh. However po kasi, pag itong A, B, C, or D clearly nasunod na ng Spouses Discaya, in that sense po or in that situation, it now becomes a ministerial duty of on the part of the DOJ to admit them to the Witness Protection Program considering nasunod na po ng applicant yung substantive aspect of the law. There are already decided cases regarding that po kung saan an initially discretionary function po of a government office becomes ministerial once masunod na yung mga requirements ng batas. Therefore, magiging proper na po yung remedy na mandamus. Okay, so yan yung potential remedy dito ni Senator Marcoleta and Spouses Discaya, assuming hindi talaga sila magkasundo ni Secretary Boying Remulla. Kung ako po tatanungin yung sa side ng Spouses Discaya, kung alam naman nila na yung iba nilang wealth, iba nilang assets ay galing from questionable sources. Okay? Kung alam nila yon deep inside na galing nga yun from yun, questionable or anomalous sources, baka naman willing na sila magbigay na ibalik na nila ahead of time even prior to the actual filing of cases. Diba? Just a showing lang of good faith. Although it is not really legally required by law, pero yun lang, para mas showing of good faith, yung taong bayan mas matuwa naman ng konti, yun, baka makonsider yun ng Spouses Discaya kasi ang tingin ko naman po hindi naman sila magbabankrupt kung let's say ibalik lang nila yung iilan doon, di ba? For example, yung Rolls Royce, I'm not saying na illegally acquired yung Rolls Royce pero kung let's say for example purposes, yung Rolls Royce nga was illegally acquired, di ko ibalik nila yun, matutuwa pa yung taong bayan ngayon kasi makukuha na nung people yung payong doon, di ba? Na mamahalin. So yan lang yung mga idea na naiisip ko. So that is one way lang po, parang middle ground lang between all the parties to ease the tension, to be fair lang sa lahat. Kasi at the end of the day po, the Spouses Discaya already issued a sworn statement where they admitted to committing certain crimes. So yung mga assets nila na related dun sa certain crimes na yun na inamin nila, baka pwede na nila maunang ibalik. Diba? Kasi kung magtuloy-tuloy yung kaso, makukuha pa rin naman talaga yun ng government. Okay, so hopefully klaro po yan. Ngayon po, yung next discussion naman natin, pag-usapan natin yung tungkol sa value ng testimony nila Engineer Bryce Hernandez, nila Engineer JP, PE Alcantara in relation dun sa pagturo po nila kay Zaldico and sa kay Yusek Bernardo. Okay, yan po yung next video after this. Okay, kita-kits po ulit after an hour more or less from the upload of this video. Bye-bye!